Hey guys, I'm Vikash Abhinav and today we will see about the case of Minarva Mills and Union of India. This case was happened in 1980 and this was a landmark case in judicial history of India. This case evolved with a basic structure, that is, doctrine of Indian Constitution. In Minerva Mills case, the Supreme Court stated that judicial review is a part of basic structure of Constitution of India. Now, let us see what is meant by judicial review. Judicial review refers to the power of the judiciary. That is, they can interpret the constitution and declare such law or order of the legislature and execute void if it finds them in conflict of the basic structure of Indian constitution. Then now we can see the facts of the case. Facts of the case is that the central government passed the Sikh Textile Undertakings Nationalization Act in 1974. This act means that the government of India will nationalize the companies which are not up to the mark that is set by the government or which is loss making. Minerva Mills was one of the such company. Minerva Mills was a textile company in Karnataka. The central government nationalized as per the said act, that is, the Sikh Textile Undertakings Nationalization Act of 1974. Hence, the creditors, shareholders, and some of the stakeholders filed a case in the Supreme Court, directly in Supreme Court, against this decision. And the petitioners, that is the side and the persons on the side of Minerva Mills, argued that the said nationalization is violating the constitutional rights, namely Article 14, Article 19G, and Article 31 of the Constitution. That is, the petitioners also challenged that validity of Section 4 and Section 55 of the 42nd Amendment made by the Parliament under judicial review. That is, the petitioners, the parties on the side of Minerva Mills Limited says that the company was nationalized or not in a proper way. So they claim that the company should be returned to the shareholders. And now let us see briefly about the articles mentioned above. Article 14. Article 14 says that state shall not deny to any person equality before the law or equal protection of the laws within the territory of India, which means that every person in the India should be given equal rights. No person shall be above or below. Every person will be treated as same under the law. Now, Article 19G of the Constitution of India provides right to practice any profession. That is, a person can carry out any profession or business in a country, but it should be legal. Then Article 31 which is right to property, which gives the right of every citizen to access their property. And Section 4 and Section 55 prevented any constitutional amendment from being called in question in any court on the ground. Now, and let us see what Article 298 states. It states that it gives the right to the central or state government to carry on any trade, business, acquire property, hold patents, copyrights on the government name. That means that government also can undertake business and they can run for profit motive or social service motive. And Article 39 Clause B states that all resources should be equally distributed to serve common good. And Article 39 Clause C states that no concentration of wealth to a particular group of people, it should be with all the people. That means that the wealth should not be accumulated with a particular group of persons. It should be equally distributed to all the citizens of the country. And Article 39 Clause P and Article 39 Clause C will come under the DPSP. That is, and next let us see that the argument of the petitioners was that the government has violated the constitutional rights, namely Article 14, Article 19G and Article 31. Now let us see the issues of the case. What was the issues in this case was whether Section 4 and Section 55 of the 42nd Amendment of the Indian Constitution are damaging basic structure of the Constitution or not. That is, 42nd Amendment of the Indian Constitution Amendment Act 1976 states that Parliament has unrestricted access. That means the Parliament has the right to change every law in the Constitution to an unlimited extent. And the next issue is that whether DPSP is more important than fundamental rights or not. And the next issue is that whether judicial review is part of basic structure or not. And the judgment that was given by 5 justices, namely Justice Chandrakshar, Justice Bhagwati, Justice Gupta, and Justice Kailasam. This was given in the majority of 4:1. The rulings struck down, and now let us see the judgments. The rulings struck down Article 4 and Article 55 of the 42nd Amendment. 42nd Amendment was we discussed above. The Supreme Court held that Article 4 and Article 55 violates the basic structure of Indian Constitution. Then both DPSP and fundamental rights are equally important. The judges said that it is like both eye of a human being. Both are equally important. This was the first case that came out with the importance of DPSP and fundamental rights. And next judgment is judicial review is a part of basic structure of Indian constitution. And the court also beautifully described the importance of judicial describe in its own words. Now let us see what was the definition given by the judges. Our constitution is founded on a nice balance of power among the three wings of state, namely legislature, executive, and the judiciary. It is a function of the judges and their duty to pronounce upon the validity of laws. That is, the judges say that the Indian constitution is divided into three groups. That is, the legislature, executive, and judiciary. And these three are very important for a country to be regulative. And this was the judgment given in the case. Thank you for watching.